So, a law already passed by California prohibits parents from knowing what medical procedures their children are receiving, but a new law would allow a whole slew of school linked services coordinators to know what's going on with their child. Hello, and welcome to Sweet Home California. My name is Jennifer, and welcome to another episode of California Crazy. Today, I am going over one of the 10 bills that the People's Convoy left DC at the beginning of this month to come all the way back to California to highlight this bill along with 9 others. This is SB 1184. And in researching this bill, I found that there was another bill that has the same number, but it's AB 1184, and that passed last year and is going into effect this July. And that's a horrible bill too. The AB 1184, oh my goodness. It prohibits any information about what the medical procedure is to be shared with the person holding the policy. So basically the parent. So if you've got anything from a 12-year-old up to, because now it's up to 26-year-olds are on the parents' policies, they can't know what's going on. There's so many things wrong with this. They're talking about, in this particular bill, the SB 1184, which is now going another step further where more non-related people can find out what your children's medical records are. And but they're in that bill I was reading, they were saying that the reason for this is because of the huge increase in the number of self-harm that kids are experiencing because they've been isolated for 2 years because of the diseases that have been going around the globe. So instead of trying to encourage children that they need to open up and talk more with their parents, they are further isolating them. So on the one hand, with the AB 1184 that goes into effect in July, kids can get certain medical procedures done that can end the life of something. They can have other medical procedures done that could ensure that they never are able to give life because they are totally messing with their reproductive parts. That can also be done on children as young as 12 without the parents' knowledge or permission. That's AB 1184. So now with SB 1184, this would hold that additional people would be able to know what's going on with your child, not the parent, but other school-linked services coordinators would have access to your child's records if it were for the purpose of diagnosis or treatment of the patient. So let me get into this. Please let me know down below what you think of this in the comments. I'd really appreciate it. And let me get over to this. Okay, so as usual, if you've been following this series of California Crazy, I've got a link to the whole playlist of all the different laws that I've gone over. There will also be a link so that you can keep track of this bill. And I will also have a link to how you can contact your California state legislators. If you are not in California, please don't click off because this is likely something that any one of a number of other blue states are also going to be considering, because it seems like whatever starts off in California, they use that as a template and they plug it in to the next blue state, be it Washington or Oregon or Colorado or anything else. So pay attention. Find whatever your particular state's website is for keeping track of these sorts of bills and be an advocate, be a voice. If you don't have a YouTube channel and you're like, but you are passionate about this, this is a great way to reach people. You can do it. I just started my channel back in July. Let me know if you're starting a channel. I'd be happy to give you a shout out. That's how I was able to get up to the number of subscribers I have, and people like you watching, liking, commenting, subscribing, sharing this video with others. That's how we're going to get the word out. I am also on Rumble and Locals, so please check out my links down below there as well, just in case anything ever happens to this particular channel. So anyhow, enough about that. latest update on this bill is that it was ordered into a second reading, and that was as of yesterday. Doesn't seem to have something coming up in the future. So the last history on this is still a live bill and still needs to be addressed and pushed back against. Okay, so here's what it reads. It says existing law, the Confidentiality of Medical Information Act, prohibits a provider of healthcare, a healthcare service plan, or contractor from disclosing medical information as defined regarding a patient of the provider of healthcare or an enrollee or subscriber of the healthcare service plan without first obtaining an authorization except as prescribed. The Act authorizes a provider of healthcare or healthcare service plan to disclose medical information in certain circumstances, including by authorizing disclosure to providers of healthcare service plans, contractors, or other healthcare professionals or facilities for purposes of diagnosis or treatment of the patient. This bill would additionally authorize a provider of healthcare or healthcare service plan to disclose medical information to a school-linked services coordinator as prescribed. The bill would define this school-linked services coordinator as an individual located on a school campus or under contract by a county behavioral health provider agency for the treatment and healthcare operations and referral of students to their families that holds either of certain credentials, including a services credential with a specialization in pupil personnel services as specified. So there is some additional information available if you click on bill analysis. Sorry. That's not correct. That's AB 1184. Hold on. If you go to bill analysis on the SB 1184, it will give you two links, Senate floor analysis and Senate judiciary, where they go into a little bit more detail as to what they envision this school linked services coordinator to be, such as like a psychologist, a sociologist, a nurse, someone who provides mental health services as well would be all a part of that. And each one of those is about 8 pages in length. Also interesting on there, it tells you who's in support and who's opposed. So for instance, the only person that they have as the only group they have as being in support is the National Alliance on Mental Illness, Santa Clara County Board of Directors. So one county, one board of directors is in support of this bill. Those that are in opposition are the Electronic Frontier Foundation, the Protection of Our Educational Rights of Kids, and one individual. Those are all opposed to this particular bill. All right, continuing on. How this bill would be enacted is they would amend the section 56.10 of the Civil Code to read that a provider of healthcare services plan, or contractor shall not disclose medical information regarding a patient or enrollee except as provided in subdivision B or C. And those are a lengthy list. So this isn't just HIPAA where you sign and say, okay, I'm going to allow my spouse, for instance, to know what's going on with me, or I will allow specifically this doctor to have access to my records. Now, this is a whole long list, so here they are. B, a provider of healthcare or healthcare service plan or a contractor shall disclose medical information if the disclosure is compelled by any of the following: a court pursuant to an order of that court, a board, commission, or administrative agency for purposes of adjudication pursuant to its lawful agency. I don't know why a whole board needs to have your medical information. Paragraph 3, a party to a proceeding before a court or administrative agency pursuant to a subpoena duces tecum. Anybody who's a lawyer, please explain to me what that means. Continuing on, notice to appear served pursuant to 1987 of the Code of Civil Procedure or any provision authorizing discovery in a proceeding before a court or administrative agency. Paragraph 4, a board, commission, or administrative agency pursuant to an investigative subpoena issued under Article 2, commencing with Section 11180 of Chapter 2 of Part 1 of Division 3 of Title 2 of the Government Code. If I ever had a thought in my mind of becoming a legislator, going over these California crazy bills has totally made my mind up, but I could not deal with this on a daily basis. All day. I mean, I've been doing this almost on a daily basis, but it's only about, 20 minutes, half an hour or whatever. This would just drive me bonkers. I don't understand why our bills have to be so stinking complicated. Continuing on, Chapter 5. An arbiter or arbitration panel, when arbitration is lawfully requested by either party pursuant to a subpoena, again that word, duces tecum, issued under Section 1282.6 of the Code of Civil Procedure or another provision authorizing discovery in a proceeding before an arbitrator or arbitration panel. 6. A search warrant lawfully issued to a governmental law enforcement agency. 7. The patient or the patient's representative pursuant to Chapter 1 commencing with Section 123-100 of Part 1 of Division 106 of the Health and Safety Code. 8. A medical examiner. This is a huge paragraph here, so let's see what they have to say about the medical examiner. A medical examiner, forensic pathologist, or coroner, when requested in the course of an investigation by a medical examiner, forensic pathologist, or a coroner's office for the purpose of identifying the decedent or locating next of kin, or when investigating deaths that may involve public health concerns, organ or tissue donation, child abuse, elder abuse, suicides, poisonings, accidents, sudden infant deaths, suspicious deaths, known deaths, or criminal deaths, or upon notification of or investigation of imminent deaths that may involve organ or tissue donation pursuant to Section 7151.15 of the Health and Safety Code, or when otherwise authorized by the decedent's representative. Medical information requested by a medical examiner, forensic pathologist, or coroner under this paragraph shall be limited to information regarding the patient who is the decedent and who is the subject of the investigation or who is the prospective donor, and shall be disclosed to a medical examiner, forensic pathologist, or coroner without delay upon request. A medical examiner, forensic pathologist, or coroner shall not disclose the information contained in the medical record obtained pursuant to this paragraph to a third party without a court order or authorization pursuant to paragraph 4 of subdivision C of section 5611. Paragraph 9. When otherwise specifically required by law. That's your whole catch-all. All right, paragraph C, a provider of health care or health care service plan may disclose medical information as follows. The information may be disclosed to providers of health care service plans, contractors, or other healthcare professionals or facilities for purposes of diagnosis or treatment of the patient. This includes, in an emergency situation, the communication of patient information by radio transmission or other means between emergency medical personnel at the scene of an emergency or in an emergency medical transport vehicle and emergency medical personnel at a health facility licensed pursuant to Chapter 2. The information may be disclosed to an employer, insurer, healthcare service plan, hospital service plan, employee benefit plan, government authority, contractor, or other person or entity responsible for paying for healthcare services rendered to the patient to the extent necessary to allow responsibility for payment to be determined and payment to be made. Now, it does say here person or entity responsible for paying for the healthcare services to the extent necessary to allow the payment to be made. However, as I already said, there's another law, AB 1184, that's already been signed into law, so that of course would limit exactly, what's going on, because they want to basically separate, the families, and this is a great way to do it. Why, we don't need to discuss these difficult conversations or anything. We don't need to know. The parent doesn't need to know if your child has certain ideations that really need to be addressed. No, we'll just trust that the government will take care of it, and that this poor, child won't fall through the cracks, right? Yeah. Who's with that child? It's the parent, right? Not some overworked social worker. And believe me, they are overworked, especially here in California. The information may also be disclosed to another provider of healthcare or healthcare service plan as necessary to assist the other provider or healthcare service plan in obtaining payment for healthcare services rendered by that provider of healthcare or healthcare service plan to the patient. Whoever pays the bills, and ultimately that's your insurer and the government, gets to know way too much about you. This is why our entire healthcare plans, they all just need to be completely overhauled. We need to be able to have some way of affording this ourselves. Whoever, writes the checks basically gets to know what's going on. And even though you might think that as the parent and the policy provider that you're that person, no, not so much. All right, paragraph 3. The information may be disclosed to a person or entity that provides billing, claims management, medical data processing, or other administrative services for providers of healthcare or healthcare service plans, or for any other person or entity specified in paragraph 2. However, that disclosed information shall not be further disclosed by the recipient in a way that would violate this part. Information may be disclosed to organized committees and agents of professional societies or of medical staffs of licensed hospitals, licensed health care service plans, professional standards review organizations, independent medical review organizations, and their selected reviewers, utilization and quality control peer review organizations as established by Congress in Public Law 97-248 in 1982. Contractors or persons or organizations ensuring, responsible for, or defending professional liability that a provider may incur if the committees, agents, health care service plans, organizations, reviewers, contractors, or persons are engaged in reviewing the competence or qualifications of healthcare professionals or in reviewing healthcare services with respect to medical necessity, level of care, quality of care, or justification of charges. I'm just so overwhelmed by all of this. Paragraph 5. The information in the possession of a provider of healthcare or healthcare service plan may be reviewed by a private or public body responsible for licensing or accrediting the provider of healthcare or a healthcare service plan. However, no patient identifying medical information may be removed from the premises except as expressly permitted or required elsewhere by law, nor shall that information be further disclosed by the recipient in a way that would violate this part. They always have their legal outs. Yeah, you can't do this except unless it's provided in some other law, and we're not going to tell you what that may be. So basically, you have no idea what's going on with your personal information, who has access to it, and to what extent it can be used against you, against your children. Paragraph 6. The information may be disclosed to a medical examiner, forensic pathologist, or county coroner in the course of an investigation by a medical examiner, forensic pathologist, or coroner's office when requested for all purposes not included in paragraph 8 of subdivision B. A medical examiner, forensic pathologist, or coroner shall not disclose the information contained in the medical record obtained pursuant to this paragraph to a third party without a court order or authorization pursuant to paragraph 4 of subdivision C of section 5611. And you wonder why there is a saying that says, the average American commits 3 felonies, before lunch. This exactly is why, because you just can't understand all the ins and outs of all the different things that people are required to follow. Paragraph 7. The information may be disclosed to public agencies, clinical investigators, including investigators conducting epidemiological epidemiological studies, healthcare research organizations, and accredited public or private nonprofit educational or healthcare institutions for bona fide research purposes. However, no information so disclosed shall be further disclosed by the recipient in a way that would disclose the identity of a patient or violate this part. Okay, so the research facilities can have your information, even personally identifiable information, but they cannot then further disclose it to somebody else after it's already gotten to that point. Wow. So your medical information, if it's part of a research study, somebody can have it with your personally identifiable information. You just have to trust that they're not going to leave it lying around, that somebody else might be able to have access to it. Paragraph 8. A provider of healthcare or healthcare service plan that has created medical information as a result of employment-related healthcare services to an employee conducted at the specific prior written request and expense of the employer may disclose to the employee's owner that part of the information. Oh my goodness. So this is now saying what can be told to your employer. May disclose to the employee's employer that part of the information that, paragraph A, is relevant in a lawsuit, arbitration, grievance, or other claim or challenge to which the employer and the employee are parties, and in which the patient has placed in issue the patient's medical history, mental or physical condition, or treatment, provided that the information may only be used or disclosed in connection with that proceeding. Paragraph B describes functional limitations of the patient that may entitle the patient to leave from work for medical reasons or limit the patient's fitness to perform the patient's present employment, provided that no statement of medical cause is included in the information disclosed. 9. Unless the provider of healthcare or healthcare service plan is notified in writing of an agreement by the sponsor, insurer, or administrator to the contrary, the information may be disclosed to a sponsor, insurer, or administrator of a group or individual insured or uninsured plan or policy that the patient seeks coverage by or benefits from if the information was created by the provider of healthcare or healthcare service plan as the result of services conducted at the specific prior written request and expense of the sponsor, insurer, or administrator for the purpose of evaluating the application for coverage or benefits. My head is hurting. I am so sorry for this. I appreciate anybody who is still with me on this. But this is important. Why? How is this good law? How does this protect anybody's individual medical privacy? It seems like everybody and their brother has access to your medical records. Paragraph 11. All right, nope, paragraph 10. The information may be disclosed to a healthcare service plan by providers of healthcare that contract with the healthcare service plan and may be transferred among providers of healthcare that contract with the healthcare service plan for the purpose of administrating the healthcare service plan. Medical information shall not otherwise be disclosed by a healthcare service plan except in accordance with this part. Paragraph 11. This part does not prevent the disclosure by a provider of healthcare or a health care service plan to an insurance institution, agent, or support organization subject to Article 6.6, commencing with Section 791 of Chapter 1 of Part 2 of Division 1 of the Insurance Code of medical information if the insurance institution, agent, or support organization has complied with all the requirements for obtaining the information pursuant to Article 6.6, commencing yada, yada, yada. Yes. Paragraph 12. The information relevant to the patient's condition, care, and treatment provided may be disclosed to a probate court investigator in the course of an investigation required or authorized in a conservatorship proceeding under the guardianship conservatorship law as defined in Section 1400 of the Probate Code, or to a probate court investigator, probation officer, or domestic relations investigator engaged in determining the need for an initial guardianship or continuation of an existing guardianship. That sounds like the situation with Britney Spears. That basically, because they were seeking guardianship, then basically everybody involved got to know her entire um, private medical records. 13. The information may be disclosed to an organ procurement organization or a tissue bank processing the tissue of a decedent for transplantation into the body of another person, but only with respect to the donating decedent for the purpose of aiding the transplant. For the purpose of this paragraph, tissue bank and tissue have the same meaning. No problem with that. Once you're dead, what does it matter? And especially it is that you want your particular organs to wind up in somebody else. That has, of course, health ramifications on whoever is going to be receiving that organ. And I suppose just as long as you know that your medical history is going to be shared when you sign up for your organ donation, that you're volunteering to be an organ donor, no worries. That part I think I understand. The information may be disclosed when the disclosure is otherwise specifically authorized by law, including but not limited to the voluntary reporting. Oh, that's good. You can report on yourself. Either directly or indirectly to the Federal Food and Drug Administration of adverse events related to drug products or medical device problems, or to disclosures made pursuant to subdivisions B and C, Section 111.67 of the Penal Code by a person making a report pursuant to yada yada, more numbers, provided that those disclosures concern a report made by that person. 15. Basic information. Excuse me, I gotta take a drink. Chapter 15. Basic information, including the patient's name, city of residence, age, sex, and general condition, may be disclosed to a state-recognized or federally recognized disaster relief organization for the purpose of responding to disaster welfare inquiries. That seems very broad. Let me read that again, because that seems like a huge violation. Basic information, including the patient's name, city of residence, age, sex, and general condition, may be disclosed to a state-recognized or federally recognized disaster relief organization for the purpose of responding to disaster welfare inquiries. Paragraph 16. The information may be disclosed to a third party for purposes of encoding, encrypting, or otherwise anonymizing data. However, no information so disclosed shall be further disclosed by the recipient in a way that would violate this part, including the unauthorized manipulation of coded or encrypted medical information that reveals individually identifiable medical information. Yeah, because nothing ever gets hacked and that information can never be, accessed by a third party. Paragraph 17. For purposes of disease management programs, now here we're getting into, 2020 era type stuff. For purposes of disease management programs and services as defined in Section 1399.901 of the Health and Safety Code, information may be disclosed as follows. A. An entity contracting with the Health Care Service Plan or Health Care Service Plan's contractors to monitor or administer care of enrollees for a covered benefit if the disease management services and care are authorized by a treating physician, or B, to a disease management organization as defined in Section 1399.900 of Health and Safety Code that complies fully with the physician authorization requirements of Section 1399.902 of the Health and Safety Code, if the health care service plan or its contractor provides or has provided a description of the disease management services to a treating physician or to the health care service plans or contractor's network of physicians. This paragraph does not require physician authorization for the care or treatment of the adherents of a well-recognized church or religious denomination who depend solely upon prayer or spiritual means for healing in the practice of the religion of that church or denomination. Okay, so I was thinking, oh, this sounds like that they're actually respecting somebody's freedom of um, to practice their religion. But no, what this says is that if you belong to one of those churches that believes just in prayer, that you don't even need a physician's authorization for the to have these people's medical care. Of course, medical records. Of course, if they don't go ever into the doctor to be treated, then I'm not sure exactly what kind of information will be disclosed. But it's interesting that they specifically um, say that if you believe in that sort of healing, that the government doesn't even need a physician's authorization to get whatever information they do have to be disclosed to government entities. Paragraph 18. The information may be disclosed as permitted by state and federal law or regulation to a local health department for the purpose of preventing or controlling disease, injury, or disability, including but not limited to the reporting of disease, injury, vital events, including but not limited to birth or death, including but not limited to birth or death, and everything in between, and the conduct of public health surveillance, public health investigations, and public health interventions as authorized or required by state and federal law or regulation. Paragraph 19. The information may be disclosed, consistent with applicable law and standards of ethical conduct, by a psychotherapist as defined in Section 1010 of the Evidence Code if the psychotherapist, in good faith, believes the disclosure is necessary to prevent or lessen a serious and imminent threat to the health or safety of a reasonably foreseeable victim or victims, and the disclosure is made to a person or persons reasonably able to prevent or lessen the threat, including the target of the threat. Paragraph 20. The information may be disclosed as described in Section 56103. Paragraph 21A. The information may also be disclosed to an employee welfare benefit plan as defined under Section 3.1 of the Employee Retirement Income Security Act of 1974, which is formed under Section 302C5 of the Taft-Hartley Act, to the extent that the employee welfare benefit plan provides medical care, and may also be disclosed to an entity contracting with the employee welfare benefit plan for billing, claims management, medical data processing, or other administrative services related to the provision of medical care to a persons enrolled in the employee welfare benefit plan for healthcare coverage, if all of the following conditions are met. I, the disclosure is for the purpose of determining eligibility, coordinating benefits, or allowing the employee welfare benefit plan to advocate on behalf of the patient or enrollee with a provider or health care service plan or a state or federal regulatory agency. 2. The request for the information is accompanied by a written authorization for the release of the information submitted in a manner consistent with Subdivision A and Section 5611. The disclosure is authorized by and made in a manner consistent with Health Insurance Portability and Accountability Act of 1996. Subparagraph 4. Any information disclosed is not further used or disclosed by the recipient in a way that would directly or indirectly violate this part or the restrictions imposed by Part 164 of Title 45 of the Code of Federal Regulations, including the manipulation of the information in any way that might reveal individually identifiable medical information. For the purpose of this paragraph, Section 1374.8 of the Health and Safety Code shall not apply. What would be really helpful is if, in the course of reading these bills, that they had hyperlinks. So when they say, Section 1374.8, that you can click on it and find out what exactly does that mean and why doesn't it apply. Otherwise, who cares? It may be very important, and that's why they kind of just gloss over it. Oh yeah, this whole section over here doesn't apply. Paragraph 22. Information may be disclosed pursuant to Subdivision A of Section 13633.5 of the Welfare and Institutions Code by a person required to make a report pursuant to 15630 of the Welfare and Institutions Code, provided that the disclosure under subdivision A of section 15633.5 concerns a report made by that person, covered entities as they are defined, yada yada, shall comply with the requirements of the Health Insurance Portability Accountability Act, privacy rule pursuant to some more numbers of the Code of Federal Regulations if the disclosure is not for the purpose of public health surveillance, investigation, intervention, or reporting an injury or death. Oh, now we get back to the school link services provider. Paragraph 23. The information may be disclosed to a school linked service coordinator pursuant to a written authorization between the health provider and the patient or client that complies with the Federal Health Insurance Portability and Accountability Act of 1996. Except to the extent expressly authorized by a patient, enrollee, or subscriber, or as provided by subdivisions B and C of a provider of healthcare service plan, contractor, or corporation and its subsidiaries and affiliates shall not intentionally share, sell, use for marketing, or otherwise use medical information for a purpose not necessary to provide health care services to the patient. E. Except to the extent expressly authorized by a patient or enrollee or subscriber, shall not further disclose medical information regarding a patient of the provider of healthcare or an enrollee or subscriber of a health care service plan or insurer or self-insured employer received under this section to a person or entity that is not engaged in providing direct healthcare services to the patient or patient's provider of healthcare or health care service plan or insurer or self-insured employer. For purposes of this section, medical examiner, forensic pathologist, or coroner means a coroner or deputy coroner as described in the Penal Code, or a licensed physician who currently performs official autopsies on behalf of a county coroner's office, whether as a government employee or under contract to that office. School linked services coordinator means an individual located on a school campus or under contract by a county behavioral health provider agency for the treatment and health care operations and referral of students and their families that hold either of the following. A services credential with a specialization in pupil personnel services as described in the Education Code, and B, a services credential with a specialization in health authorizing service as a school nurse as described in the Education Code. So if you are still with me, God bless you. This is so overwhelming. I think we just need to scrap our entire legal system and just say, you know what? You don't have any right to expectation of healthcare privacy. It would, in effect, be the same thing, and at least we would know that we're not under any illusions that we have any sort of medical privacy anymore. Let me know your thoughts in the comments down below. If you oppose this bill, which I think you should, please see the links in the description so that you can let your voices be heard here in California. And as I said before, check out your own state legislators if you're not here in California, especially if it's a blue state. I would have no doubt that expanding the government's access to your personal medical information is no doubt